Well, Parliament held its first public hearings on the upgrading of Land Tenure Amendment Bill this week. The proposed law seeks to secure and officially recognize land rights held by those living on customary and informal land. It also seeks to invalidate the current law, which in its current form discriminates against women's land ownership rights. Joining us now to discuss whether the bill goes far enough to address land ownership injustices and the cause of women is researcher Nomboniso Gasa. But first, let's hear how these proceedings went from the chairperson of the Portfolio Committee on Agriculture, Land and Rural Development, who chaired this week's submissions.
We've received a number of activist organizations and representatives of communities, as well as women groups that advocate for women ownership of land. We received about 110 submissions, which we have had over 40 of them in the past 2 days. There has been already about 480 submissions that would like to present orally, which has required the Portfolio Committee to ask for an extension for 2.5 days from Parliament next week, ending on the week of the 28th of August. The women, particularly coming from the National House of Traditional Leaders, as well as Contralesa and from NGOs and civil society, were able to come and testify and give evidence as to what the issues women are experiencing. But I think also one of the important calls that was made was for single mothers that are raising their own children without a real land tenure right. And they are looking to ensure that, particularly in traditional leaders' communal lands, that women are able to be afforded the right to land.
Nomboniso, it's Lindi. Good afternoon to you, and thank you so much for joining us.
Good afternoon, Lindi, and hello to your viewers.
Sure. I mean, would you say that the proposed new law that's now under discussion, does it go far enough to address South Africa's land ownership rights?
Obviously, it's not. I mean, this bill, well, basically the law is specifically for a number of issues, so it won't address the entire land question. The upgrading of land rights, land tenure rights amendment bill is basically occasioned, at the moment the debate is occasioned by two constitutional court cases, the Rahube case and the Teba case. The Rahube case was dealing with the automatic conversion of deed grant into ownership. The Teba one was basically dealing with conversion of permission to occupy. So here are key issues in this that are highlighted. One is the issue that we've always been talking about, that in South Africa we need one overarching law to begin with that deals with land rights, or rather with land. That there are certain principles that have to be set out in an overall law. For example, the right to own land, how land is acquired by people, the protection of people who live under customary law, or what in the proceedings in Parliament was referred to as permission to occupy. So the first issue that I would like to say about this bill is that the whole process that Parliament is having of approaching the land rights law building process in piecemeal is actually very inadequate. So irrespective of what this bill, for example, let's say if we were to achieve all the things that we want, there would have to be cross-checking with other pieces of legislation, for example, the Traditional Leadership Governance Framework Act, the COISAN and Traditional Leadership Act. All those pieces of legislation actually have a potential to undermine, in fact, they undermine whatever rights that are provided by various pieces of legislation. So that's the first thing. So instead of Parliament taking one bit by one bit, I think it's important to have an overarching law and be very clear about the constitutional principles and the rights that are there. The second one is Parliament's continued dabbling with traditional leaders in the first place, trying to pretend as if there are certain things that they can give to traditional leaders that in fact constitutionally they are not going to be able to deal with. One, you see Ingonyama Trust in its submission asking for exemption of women's right to own land in land that is under Ingonyama Trust. Obviously that is unconstitutional, but if you have an overarching law and principles and you set all these things out very clearly, you would be able to ensure that Ingonyama Trust is under no illusion that special rights and exemptions would apply to it.
Sure.
So I think the first thing is that whatever this process results in, it has to be obviously checked against the Constitution. But I think more and more people are saying, look at the high-level panel of the Motlanthe that was headed by former President Motlanthe. Look at their recommendations about how we should go about ensuring that there's clarity and ensuring that there's consistency, whether it's in a rural community that falls under customary law, whether it's in an urban township, or whether it's in Sandton, or wherever it is, that South Africans have same rights of access to land that are protected by the Constitution, and that there should be no exemption from that.
Nomboniso, I think one of the important things you touched on is how this law deals with the ownership of rights for more vulnerable people living on customary and informal land, right? And you've spoken about the Ingonyama Trust. It must be shocking that in 2020 you hear the chairperson of this trust who says, well, if women have access to this land, it will actually do more harm than good. What needs to be done about that sort of belief that women should not be able to access that land? And would you agree with some who say, well, maybe we need a complete overhaul of the system to rectify this issue?
But that's precisely what I'm saying, that when you have an overarching legislation, a piece of legislation that actually shows what is the attitude of South Africans, to land, and clarify all this, that's about overhauling the system. But I think that Judge Ngwenya, who made the submission for Ingonyama Trust, is able to make those, assertions and submissions to Parliament because politicians have sort of like at different points given the impression that they can, they can grant Ingonyama Trust what it wants. So, so this is part of the consequences of pandering. That politicians have been doing for a long time. And of course, it is not shocking to many people who live in these communities under Ingonyama Trust, or people who live in rural communities that are considered to be governed by traditional leaders. It's not shocking because these are the everyday realities that people live with. But I think it's important that these challenges are being brought into the Constitution in terms of Constitutional Court challenges, but also that people like Judge Ngwenya go to Parliament on a national stage and they are seen to be making these assertions by the rest of the country. I think we need to be clear about what land ownership, what land rights and what land administration means in this country. We need to deal with some of these icky issues around customary law, these claims that because of customary law, women cannot have rights to own land. We need to clarify this. We need to deal with this. So that's what overhauling of the system really is about. But at the moment, we're dealing with this thing at the piecemeal. So in terms of this legislation, I think it's very important for especially people in the media and people who shape public opinion. I think it's important to report what women in these communities, what people in these rural communities are struggling with, and the kind of issues that they are raising. Because it's one thing to talk to me, but I think it's important to actually talk to people and hear what people are saying, and hear people under Ingonyama Trust who live in land that is controlled by Ingonyama Trust, to hear the kind of daily struggles that they have, and to hear the kind of victories that they've been having against Ngonyama Trust in court. So this is an invitation, I think, at this moment for all South Africans to engage in this kind of debate, but also send a very clear message to politicians that there will be no pandering to institutions that want to undermine the rights of women.
Absolutely. Nomboniso, before we go, we've got about a minute left, but I do want to ask you, I mean, the land reform debate, it's still ongoing. There's still outstanding matter of land expropriation, and some add, you know, without compensation in South Africa. Could this new law help towards that debate in any way?
No, this law deals with very specific, with a very limited area of land rights. I think that obviously, if you look at how you attack the elephant, maybe you can take bit by bit and bite the elephant little bit by bit, and then you defeat the animals. So I think it's important at every stage that these rights are affirmed. So that's why this law is important. But it can't really help in the overall debate around land ownership, around access to land, around whether land should be expropriated without compensation. I think it's important for us to talk about exactly what we envisage to be the land regime in this country. Because even if you do expropriation without compensation, we know that that land is not necessarily going to go to poor people. It's not necessarily going to go to people who are going to use it the most. So there's a very important conversation that we need to have about what kind of land regime we want in this country, and the big topics like land expropriation of land without compensation are very exciting, but I think that we need to discuss the detail and the actual land regime that we're looking for.
Well, we'll leave it there this afternoon. Nomboniso Gasa.